Hello, everyone. Derek Johnson with Tatango.com. This is another TCPA case review with Joe Bowser from Innovista Law, home of the TCPA Defense Force. How you doing, Joe?
I'm doing well, Derek. How are you?
Can't complain. So we have another case today, and essentially we do these case reviews to not only kind of tell people what went on with the case, but also how text message marketers can learn from this specific case. So this case right here is, and I bet I'm butchering the name, and I butcher a lot of these names, it seems like, is Viggiano versus Kohl's Department Stores. So everybody's familiar with Kohl's, and Viggiano is a person. So it's a person versus Kohl's. And I'm going to read from some of the summary that I've been given here, and then we can jump into maybe any details that I missed, and then what happened with this case, and then lastly, how text message marketers can use what was determined in this case to make sure, that they're compliant with their text messaging campaigns. So Kohl's Department Stores, they had an SMS marketing campaign. And actually, I think if you go into Kohl's, they advertise it pretty heavily. And essentially, people opt in the United States. You have to opt in for recurring text messaging campaigns. That's kind of step one of any text messaging campaign. So this consumer, Viggiano, that's their last name, right, Joe, usually?
Correct. Yep.
Okay, perfect. So this consumer, they opted in, and it looks like from my notes here, she claimed, and this could have been in the original lawsuit or could have been kind of in a deposition later on, she claimed that she initially consented to receive the text. So that's not in debate here, right? She opted in to receive mass text messages from Kohl's.
Correct.
Am I okay?
This is what she alleged in her complaint, which is the very first document that a plaintiff files in a civil lawsuit.
Okay.
So she told this story in her opening document.
Okay. So the issue here is not, and sometimes and very often it's about consent. People, maybe they put their phone number in a fishbowl, maybe they call the business, and then the business is now text messaging them. Then there's an issue with, was consent received to receive text messages or not? In this case, she actually admitted that she consented to receive the text message. The issue that this consumer has is after a certain amount of time, and I'm pretty sure you'll know this in a little bit, but after a certain amount of time, she decided that she did not want to receive any more text messages. So currently, when a consumer, wants to opt out, usually they reply stop or unsubscribe or quit, and most SMS marketing software providers will automatically essentially remove that phone number from receiving future text messages. Correct. Similar to kind of like email marketing, you click on that little email unsubscribe link, and then it should remove you from the email list.
Right. So
this person, though, and I guess I know her name here, it says it's Amy. So I'm going to say Amy from now on because that's much easier for me.
That'll work.
She, instead of responding, stop, cancel, quit, unsubscribe, or end, which actually is required by the wireless carriers and the CTIA, which actually is not required by the TCPA. Like in the TCPA, it's not that specific when it comes to text messaging. Text messaging is not even mentioned in the TCPA, right?
Never once.
Okay, perfect. So a lot of people think that message and data rates may apply, and text stop to, stop or end or quit or help. Those things are in the TCPA. That's actually in the CTIA guidebook, which the CTIA, well, it's important. It's not law. The only thing the CTIA can do is suspend or terminate your short code, where the TCPA, a consumer can bring, a lawsuit against the brand for text message spam. So this person, Amy, instead of replying stop, end, or quit, or unsubscribe, there's a bunch of them, she responded, and I'm reading from my screen here, I've changed, and this is her, I've changed my mind, and I don't want to receive these anymore. Then she also texted, please don't send any further messages. She also sent, I don't want these messages anymore. This is your last warning, with an exclamation point. So she was very serious on that one. So what's interesting here, I think, is I can understand if you're an old person or maybe somebody that isn't familiar with, text message marketing, or maybe you didn't opt in, so you didn't get some of the instructions on how to opt out at the beginning. I can see that's very frustrating. Now, what's interesting about this Kohl's case, and it says this in the lawsuit, is that when she texted these, essentially requests for her to opt out, Kohl's automatically, which is the right way to do it, their software, or then, depending on who they're using, they responded automatically, sorry, we don't understand the request. Reply help for help, stop to cancel.
Right.
So it's interesting here because we've seen some cases in the past where, the person responds back, hey, I don't want to receive these messages anymore. And then they just get nothing back, which is confusing for the consumer. This is very obvious for the consumer, and they're just not following the instructions. Do I have that right?
You do. She basically agreed to receive these messages, and then one day decided that she no longer wanted them. And then in her mind, she converted these messages to spam and said, I don't want them, and gave these narrative responses, never texted stop to the campaign or the keyword at issue, or the short code, as it were. And then she sued.
Okay. So she sued. Now, was she suing like as a class action where
She was.
Okay, so she was saying, I bet a lot of other people want to join this, or she was essentially telling Kohl's in the court that was her intention. So she sued, and where did it go from there?
Well, in this particular case against Kohl's, there are others. Kohl's had sought MDL treatment, multi-district litigation treatment, for the cases that it had brought against it around this time period. But Ms. Vigiano's case went just to the motion to dismiss stage, where Kohl's filed a motion to dismiss, which is a paper that a defendant will file and essentially invites the court to say, even assuming that everything this plaintiff says is true, I still win as a matter of law because her complaint doesn't state a claim that could ever be successful.
Okay.
So that's where this case ended up. The court agreed with Kohl's at the very first hurdle that a case has to clear, which is that motion to dismiss phase.
So they didn't even do any depositions. It essentially went, she filed the lawsuit, and a consumer has to get their own attorney, right?
Correct.
Okay, not for small claims court in some places, right?
That's right. Right. But this is in federal district court in New Jersey. So she would have needed an attorney to represent her to file a class action. She could have filed the claim pro se, what's called pro se, by yourself.
Okay.
But because she was bringing it as a class action, she would need counsel for that.
Okay. So she filed the lawsuit, and what damages were she alleging? Because I personally know, because I've been doing this for a long time, that you don't need to actually have like damages, like prove the damages. But how does that work? Like, and what are the amounts, and why don't you have to prove damages when in like a car wreck or you're injured by somebody, you get the money usually that, compensates you for the damage that was done. How much damage is done just receiving a text message?
Well, so the TCPA, Congress chose to give plaintiffs a choice of proving their actual damages, which are the kind of damages you just mentioned when you're in a car accident, right? Okay. Your car suffered this much property damage. You had bodily injury of this value. You add those together, and those are your actual damages. Well, in a text message case, you might be able to show that if you had a plan where you paid a per message charge to your carrier, those, if you paid a penny a text or something, you'd have to add up a lot to be able to get to the statutory damages that Congress set up, frankly, as an incentive to get plaintiffs to sue these kinds of companies that were sending unlawful messages, or in back then calls, to try to get them to discourage that adverse behavior. So The plaintiff gets to choose between their actual damages on the one hand and statutory damages, which are either $500 per call or text if it's a negligent violation, or if it's a knowing or intentional act that violates the TCPA, then it's $1,500 per call or message.
Okay. And so Congress was the one that established the TCPA, right?
Correct.
Okay. So they were trying to essentially say, let's put a big enough fine there so that it's worth a consumer's time to go after these people. Because if you could only sue for $1, I'm not going to waste my entire day or months of my time or years of my time, suing a brand for $1. So it made it a high enough threshold that it was worth it for a consumer to actually like go after the business.
Well, sure. And in 91, when the law was passed, there probably weren't actual damages, right? Everybody was getting calls during dinner on their landline. Commercial text messages didn't even exist until 93. So Congress certainly didn't have text messages or mobile phones in mind when it passed the TCPA. It was the FCC and courts that later interpreted the phrase call to include text message. So in any event, Congress didn't think that anybody would bring a case unless there was a sufficient incentive for people to go to court. So Congress created these statutory damages to essentially incentivize these so-called private attorney general cases where individual citizens would go and take bad actors to court, even small claims court, to try to recover those statutory damages to discourage that kind of behavior that was interrupting people's, dinners in the evening and things like that, because we were all getting calls on landlines back then.
Yeah. And so in those statutory damages are $500 to $1,500.
Correct. Based on the level of intention in engaging in any particular call or campaign.
Okay. So this woman filed this lawsuit, and why recently, or was the original intent from Congress, hey, there's going to be a bunch of class action lawsuits? It seems like it was more like individuals could bring, suit against a company, but it seems like recently it's more consumers banding together, essentially suing brands. Is that a new thing, or how's that kind of?
It's relatively recent. It really wasn't until the last 5 or 10 years where the TCPA case filing curve has really spiked exponentially. It finally leveled off last year. And our view is that just more and more cases are getting filed as class actions as opposed to individual cases.
Okay.
But, we hit a peak in 2016 of over 5,000 TCPA cases. It's the second most common type of civil litigation in the federal courts. So the combination of the federal rules relating to class actions generally, right? You can bring class actions for all sorts of consumer violations, securities law violations, what have you, employment issues. So the federal rules of civil procedure deal with the class action vehicle as a general matter. And then the plaintiffs bar and the plaintiffs attorneys have realized that this is an area of the law where they don't need to invest a lot to get potentially huge returns. So where 10 years ago asbestos was clogging the courts, those are expensive cases for the plaintiffs' lawyers to bring. You need the doctors. You need to amass the key level of experts that you need to prove that, these class of employees were injured because of their exposure to asbestos or whatever, professional level of exposure to toxic torts and things like that. But again, those are expensive cases to prove. So the TCPA has essentially become the next asbestos. And at most, the plaintiffs' attorneys invest in one or a handful of so-called experts who basically opine that anything that the defendant uses is an automatic telephone dialing system. In our experience, they kind of recycle their reports, and there isn't a lot of heavy lifting that the plaintiffs' attorneys and their experts have to do to get these cases to the class phase.
Okay, so it's just an easier, lawsuit than something like car wrecks or asbestos or something along those lines, because, it's, hey, did you receive a text message? Okay, you're entitled to anywhere from $500, $1,500. You don't have to send expert witnesses to the house and do forensics and, medical documents. It's essentially, did you receive a text message or not?
Correct. And right. And for class certification purposes, the plaintiff's attorney wants a situation where no one class member's factual pattern is terribly different from the others, because the minute you have to have mini trials, then the arguments for class certification really start to get diluted, and it's harder for them to grow those big cases and extract those large settlements that you see in the Wall Street Journal and other trade press.
So these mass text messaging campaigns, if not done correctly, are great opportunities for these plaintiffs' attorneys, because in the case of a mass text message, everybody's getting the same message. It's the same violation if, they haven't opted in, where, if you work near asbestos, you might have worked outside or closer to it, or it's not as easy to claim that everybody was affected exactly the same way.
Well, sure. You're right. In those cases, you want to know, did you smoke for half of your life? Just obvious things, right?
Okay.
Where, you need medical opinions and things like that.
Now, the 5,000 TCPA cases, what are those cases? They're not just text messaging, right?
No, the TCPA regulates phone calls,
okay,
faxes, and SMS.
Okay, and
so
even MMS,
three channels.
Mobile messaging that, SMS, MMS, something like a text message, essentially.
Correct.
Okay. So not all of them are text messaging, but I guess the nice thing about faxes and even text messages, there's kind of a record there. It's easy to show. A phone call is a little harder because most people don't record their phone calls, obviously. So it seems almost kind of like, again, easier, from the text messaging and fax side than it is like a phone call. Okay, so this consumer, she was upset, obviously. Now, do you have any indication that this consumer was trying to game the system? Because Kohl's, it looks like, was being very responsible as a brand and responding back with instructions and very clear instructions. It wasn't like they were hiding the opt-out instructions like some people do in email marketing. They put it at the very bottom in the same colors, the text or, the background. It seems like they wanted her to get out of the campaign. She just didn't take, her own initiative to opt out.
Yeah, it doesn't look like there was much else that Kohl's could have done to reasonably facilitate her ability to opt out. Now, I obviously won't comment on her motive. Certainly, professional plaintiffs are not uncommon in TCPA lawsuits. I don't know whether she is one or not, but she did appear to avoid the easiest way to opt out, and so that's one factor in evaluating whether she had a pure mind in filing the case in the first place. But in fairness, there is no shortage of TCPA plaintiffs' attorneys who are looking for clients. So if you Google, unwanted text messages and things like that, there are a number of plaintiffs' firms who have websites set up to facilitate your ability to become a plaintiff with essentially very little effort on your part.
Okay, so they're looking for these types of cases. Now we had another episode where there was a case in South Florida. Some of these folks, some of the plaintiffs' attorneys have billboards in South Florida where they really are heavily advertising as though it were personal injury law. So it almost could be that the consumer doesn't even realize that there's this TCPA stuff, but they see a billboard, they search unwanted text message, and then they're like, oh, $500 to $1,500, this could be an opportunity, which I think just makes it even more important to know the TCPA and to comply with it, not only because, the $500 to $1,500, but, if you have an attorney kind of advertising and promoting the fact that there's $500 to $1,500 to be made, it just increases, I guess, the risk, which again can be mitigated by actually, doing your homework and consulting attorneys and really complying with the law. Right. They're not all like this, but in our experience, and I'm obviously on the defense side, we certainly come across more often than we want plaintiffs' attorneys who don't really do the investigation that we'd hope they do to evaluate whether the claim has any merit. So a lot of times they'll file first and think later, or just put the onus on the defendant once a lawsuit's been filed to go then gather the consent records and establish that their case has no merit, the plaintiff did in fact consent to receive the messages, and that frankly the claim is frivolous. Okay. So does Kohl's, because I think we've discussed this in the past, and I think there's been some court rulings about this, I think in the TCPA, because it doesn't mention text messaging, it doesn't mention text stop, first stop, I think it essentially says somebody can revoke their consent from receiving messages. Mm-hmm. And wouldn't that make Kohl's kind of liable here? Like, she technically did revoke her consent. Couldn't she also go into a store and ask an employee, hey, I just don't want to receive the text messages, unsubscribe me? Couldn't she stand outside the store and yell it? Like, where I guess, has the court decided, because this has been thrown out, that only one type of revocation of consent works? Or I don't know, where do we stand right now? Well, that's what this case was about. This case really turned on whether Kohl's mechanism for opting out was reasonable, and whether Kohl's unduly restricted her ability to unsubscribe or revoke her consent. Now, had Kohl's created some labyrinthine
a process for opting out and said, you have to meet me on a street corner on a third Tuesday in the rain, that would violate the FCC standard that a consumer can opt out via any reasonable means. So what the court was doing here was applying that FCC standard about a consumer being able to opt out via any reasonable means. And the court was evaluating whether the plaintiff's preferred means, which are these long narrative sentences that avoid the word stop with a computer or, an algorithm, whether that was a reasonable alternative to the one that Kohl's had on offer, which was to text 4 letters that was in every message they apparently sent her.
So this is more about that, the existing way, especially because they replied back, replies stop to cancel or whatever. That was more about, is the response and everything reasonable for her to opt out, where not going and looking at like, okay, what other methods were available to her, or what other methods could another business, assume that would be, reasonable. That wasn't about this case. That was just about this specific use case, essentially, for her responses. The court didn't decide, okay, well, you could also go to the store and ask an employee. Has that been decided yet?
That narrow fact pattern has come up in some cases. There hasn't been a clear decision one way or the other at the circuit level, which is, really the level where those rulings start to become binding on the lower courts. So in light of the FCC's any reasonable means standard, we're still watching these cases come through the lower level courts, the federal district courts, and develop some body of law. And we've talked about several of the cases like this, where platform providers and brands are offering the stop and quit and unsubscribe and the other CTA required opt-out mechanisms. And we've had multiple cases now say that is effectively the only reasonable way to opt out. And we've got the plaintiffs on the one hand texting these narrative responses that if you or I read them, we would understand their intent, but you're communicating with a computer.
And I guess that's a good point and maybe people that aren't familiar with text message marketing, when you send a mass text message, especially if you're a Kohl's, Subway, Chipotle, a large brand, you were sending a mass text message to millions of phone numbers. Again, opted in, so these people want it. But a lot of people, we're talking 1 to 5%, depending on kind of the campaign and the brand, will just respond to the message. They'll respond to everything from, stop and quit, help, stuff like that. They'll respond with words and phrases that may be like, hey, I need help. And some will just respond random stuff to see what happens. Some will send in photos. It is ridiculous how much stuff just comes in after a mass message. Now, majority of SMS software providers and brands essentially just kind of ignore those messages because most of them are just kind of help, stop, and they're automated responses. So somebody replies help, it automates the message. Somebody isn't looking through each individual response and addressing those concerns.
Right.
So that's where this issue come up, because I bet if a Kohl's, employee was managing the replies, they would have opted the person out, because no one wants to keep a person that doesn't want to be opted in.
Right.
But because, no one is managing those replies and it's, a computer assisted program, they just essentially reply back. And I think they did in the Kohl's case. They just said, hey, that's an invalid response. So it doesn't match kind of one of our predetermined responses. Text help for help, stop for stop.
Right.
Okay. It's interesting. And I think it's a good call to action too, because I know we've also talked about, lawsuits where the brand actually doesn't have that response set up for those invalid responses. So for the text message marketers that are listening right now, next, mass text message you receive from your brand, respond back and say, hey, it's a great day out. What are you eating? It's just something random to see what the software provider actually is sending back. And if it's sending back something like, your response has been received, well, maybe that's not enough info for the consumer to, know that they can reply help for help, stop for stop. And also we even encourage some people to add into that message, maybe say, this is, not a channel that you can respond to. essentially kind of like a no reply email address,
right.
where this is an automated response. These things are not monitored. If you need help, reply, or email support at, companyname.com. If you want help, reply help, and if you want to stop, reply stop. You get 160 characters in these messages. So you can fill it up with even links and phone numbers. I think you want to be as clear and give as much information as to the consumer as possible, because, well, this, plaintiff, maybe they were trying to game the system. And again, I don't know, but there are consumers out there that just forget, and they're like, man, I can't figure out what was that word that I have to respond back. And they try, weird things like, I don't know the word. What is it? And if it's just responding without nothing, or with, just your response has been received, the consumer frustration level is going to go from here to here to here. And every time they get a message, it's going to keep going up.
Right.
And at a certain point, I think for regular consumers, not like professional plaintiffs, there's going to be a certain point when they're going to start searching for, unwanted text messaging, and then they're going to see these lawsuits. Right. So I think it's just kind of preventative maintenance for a text messaging campaign.
Yeah, Kohl's didn't have to do that here. We've talked about other cases where brands didn't include that help for help, stop for stop instruction when they got a message that they couldn't understand, and that the computer couldn't understand. But it's just helpful for, as you say, for the brand management perspective.
Yep. So what can text message marketers learn from, I guess, mitigating the risks here? And also, how long did it take from the time that the lawsuit was filed to when it was actually thrown out, I guess? How long a process is that without any depositions? And like, that still seems like a long process for some reason.
Yeah, it's relatively brief in the lifespan of typical litigation, but this one was resolved within several months.
Okay.
So the lawsuit gets filed, it's got to get served on Kohl's. They get so much time to respond to the complaint, and then you're waiting for the court to resolve it. And this particular court, the Federal District Court in New Jersey, is fairly busy as the federal courts go. So you're not going to get on their radar as quickly as you would judges with smaller dockets.
Now, is there anything that a brand can do, like in this, specific situation, that they can, decrease their chance of receiving a lawsuit similar to this? Or is this just one of those things, if you're playing in this space, there's a chance that you could receive one of these type of lawsuits, and you have to defend yourself there, and that costs money and takes time.
Right. I mean, it is America. You can't stop people from suing you. I think the only thing that Kohl could have done, in addition to what it was already doing in terms of letting the user know that she should reply help for help, stop for stop, is maybe to give a bit more of that narrative discussion about how I'm a computer. I really can only understand certain keywords. Right. So just drive home the point that these really are magic words.
Okay. Because that makes it easier also if the lawsuit is, brought to a court. A lot of these judges, and I would say the majority of them, some of them don't even subscribe to SMS alerts. Some of them don't even know what a text message is, or they've seen their grandkids use text messaging, but they don't. You're having like somebody that is not an expert, like you or I, or the people that are watching this video, assess these kind of interactions via text message. So the more, information, and the more, kind of common words and making it simple for people to understand, the more the judge can actually understand it as well. Because, you could see a judge being like, I don't get what that stop to end means, and everybody else is like, I get it, so then that could just drag out, a case. So I guess reiterating, you have 160 characters, say it 3 different ways in the same text message if you need to.
Right. And make sure that you're keeping good records, right? So if she texted in by seeing a call to action in the store, you want to be able to tell that user experience story from beginning to end. So if you have gaps in your story because you don't have the records, all of a sudden the judge might not feel comfortable dismissing the case at the early stage, and may conclude that you need to go to discovery and have the case get resolved on what's called summary judgment, which is after a reasonable amount of discovery is done. So, credit to Kohl's here for being sure that they had the evidence that they needed to tell the story from beginning to end.
And that's a good point I think you bring up, is the evidence, a lot of brands, like let's say Kohl's for in-store advertising, they're advertising on kind of, a big poster or something like that, or an end cap. Most brands think that the evidence is the text messaging log, just solely like text join, you get the reply yes, you reply yes, you're opted in, you get mass text messages. But that doesn't paint the whole picture, especially for somebody that may not even know what text message marketing is, like a judge. So you also recommend, and we always recommend, to keep like photos of the call to action. So go to the store, take a photo from different angles, and every single, way and place that they could opt in, and store those on like a Google Drive or Box or Dropbox, and essentially just keep those there for a long time, so that if somebody comes, in the future, you have that full narrative, not just the text message narrative, which I think a lot of text message marketers, I think they only have the text message narrative. They don't keep any of the other stuff.
That's right. Yeah. You want to be able to tell the story from beginning to end.
Okay.
Because whether it's the judge, whether it's the jury, if it comes to that, you want to be able to tell the whole story so that, again, a picture, really can be terribly powerful in telling that story and say, you really didn't consent, or you thought that was a reasonable means of revoking your consent, when you knew that this is how the program operated. So why would you all of a sudden start sending postcards when you knew how to opt in on the front end via SMS?
Yep. Okay. And record keeping now, and we're talking screenshots, we're talking text message records, we're talking, photos, if it's a billboard, any text message record, I think helps, obviously. How long do these brands need to keep them, and should they just keep them forever? Storage is so cheap nowadays. What are kind of the actual legal recommendations for keeping these records, both text messaging and, the photos and the call to actions?
Well, so the TCPA has a statute of limitations of 4 years. So that's the minimum, right? So you can be on the hook from the filing of the complaint date back 4 years.
Okay.
But if you started that campaign before the end of that 4 years, you want to go back even farther, because that's where your consent came from.
Okay. Right? So you could have opted in 8 years before.
Right. So you basically want 4 years plus the life of the campaign.
Okay. So in my always recommendation, just keep the records forever. And that also means I see a lot of text message marketers, maybe they discontinue a text messaging campaign. That doesn't mean it's time to delete all of your files and records. It's not like a regular marketing campaign, because there are these plaintiffs out there that are looking, and there's huge, damages. So really try to keep it for as long as possible, but at least 4 years plus the length of the campaign.
Well, and the real reason is consent is what's called an affirmative defense under the TCPA. Okay. The plaintiff doesn't need to allege that they didn't consent to get a message, right? They don't need to prove any of that. If we have the right and the consent to send a text message or make a call, it's on us, the defendant, to prove that in court. So we have the burden. So if we get rid of our own records showing consent, we've just shot ourselves in the foot, right? Because now we need to rely on testimony about the typical practice of the company. And the best evidence, of course, are the actual consent records. Okay. So you make your life so much easier if you just hang on to that, because it's our job to prove it. And it's better to use the direct evidence rather than circumstantial evidence, like the head of IT or marketing explaining how a given campaign worked, and then the jury or the fact finder is expected to assume or conclude that in this case that's how it went as well.
Yeah, and those employees might no longer be around. They might have passed away. They might have moved to a new company. Right. Keep the records, and every record on the text messaging side as well. Not just your mass text messages, not just people that text help or stop or unsubscribe, every single record. Because, even at Tatango, we've had to do some kind of looking into a phone number, and essentially, you need to see kind of every little action that phone number is taking on that short code, and trying to create a narrative of, okay, this person, didn't even opt in at start. They just started texting random stuff. Then they opted in, then they responded back. Like and then, they weren't even in the list and they were messaging. Like, you want a whole kind of narrative of what this person has been trying to do. And then you can also kind of, I guess, craft your defense also based on kind of, the narrative. If it seems very, suspicious that, it seems like they were trying to game the system rather than, hey, oh, geez, man, they've replied stop and the software just broke. Oh, well, that's a different defense and that's a different strategy.
Right.
Broken software compared to, a professional plaintiff.
Right. So a lot of these professional plaintiffs obviously have more than one phone. And then, they allege that, like manna from heaven, they just got, subscribed to these 10 programs. They have no idea how it happened. But when you can show that, in a reasonably close period of time, they subscribed to multiple campaigns and they're telling you that, oh, believe me, I didn't sign up for any of this. It doesn't look terribly credible.
Yeah. So keeping all records. Now, what, when somebody, because I know there's also, before a lawsuit is filed, some of these professional plaintiffs, some of these plaintiffs, they will file they'll send a demand letter to brands like Kohl's and say, hey, pay up right now or we're going to sue you. When should a brand kind of take it from their marketing department and pass it off to either inside or outside counsel to handle? Because I know that's a big kind of concern because, some of these brands get these demand letters and then they look at the record and they go, well, this person opted in. Well, let's just respond and give them the text message records. Mm-hmm. Is that the right way to do it? Or should they, the minute they get, the threat of a lawsuit is when they actually involve legal counsel?
I would involve legal counsel, at least in-house, whenever you get notice of a potential lawsuit. There are a number of teams within the company that you want to get involved there because there may be insurance coverage issues you want to look at. Obviously, you're going to want to get the marketing and IT folks to pull the campaign and consent records. And then in-house counsel should have an opportunity to evaluate and do some factual investigation because the marketing folks may not have the same type of perspective about what's going on in the courts relative to the TCPA, the exposure for the company writ large. So, and then you want to make sure that if you want to keep certain communications privileged, so that if a lawsuit is filed, you want the investigation and those kinds of communications to be protected either under the attorney-client privilege or attorney work product. But if the business people are just talking amongst each other, and you have Johnny telling Jenny, oh my God, we just sent this text message we shouldn't have. That's not a great email to have to produce in discovery. And if this wasn't done at the direction of counsel, it's harder to argue that those types of communications are privileged. So getting legal counsel involved can help protect from the privilege perspective. A lot of insurance policies are so-called claims made policies. So if you don't make timely notice of a claim to your insurance carrier, you can compromise your ability to get coverage for those claims. So it's not just that claim that's at issue, right? You want to make sure that all aspects of the company's risk management portfolio are being accounted for and have a chance to weigh in on how to respond to that.
Okay. And also, I think the text message marketing provider, the gateway, because they also have resources as well, to look through, things like the full text messaging records. We can look at, okay, that phone number, yes, texted you, but it also texted, 15 other brands.
Right.
Maybe we also know that one of those other brands have received another demand letter from them. Maybe we can share some of that info and connect those clients together and their legal counsel together. So I don't think it's one of these things that you want to hide. I see a lot of people like, we're getting these demand letters. We kind of need to button down the hatches and, not tell anybody about this. I think that's the wrong way to go about it.
Well, that, and if the letter really is highlighting a potential area where compliance isn't perfect, you want to fix it.
Yes.
Right?
Why? 100%.
Why keep doing something that may be putting the company at risk? So if nothing else, just stop the bleeding if there is bleeding.
Yeah. And we've seen some clients, not obviously Tatango clients, but I've seen this in the past where, there is a threat of a lawsuit or a lawsuit and they automatically shut down the campaign, message everybody. And it seems like it's a little knee-jerk reaction where, I think that's where you have to involve all aspects of your company, your team, the SMS provider, even the wireless carriers, and really come up with a plan, to what the future of this is going to look like, rather than just automatically sending everybody a message going, hey, we're shutting it down, because you can lose millions of real true opt-in phone numbers that, after, a few months, you might have learned that, hey, what you were doing was completely okay. You just had to deal with kind of this nuance.
Yeah. And it's understandable, but some folks just get defensive or get nervous, like, oh, what did I do wrong? Mm-hmm. And a lot of times the answer is nothing, right? Yeah. With reassigned numbers and other issues, perfect TCPA compliance isn't always possible, right? If customer A opted in and they lost their phone number and it got reassigned to customer B, and you don't know that, customer B might get a message that might violate the TCPA. Obviously, that's an open issue now with the DC Circuit's ruling and the ACA opinion. But, there's no reason to think that, my job's at risk just because we got a demand letter. These plaintiffs' attorneys send lots of demand letters.
Yeah. So you're not the only marketing person that is getting one of these. There's a lot of them going out, and way more, I would assume, than even 5,000. Those are the ones that actually get filed as lawsuits. I've heard there's a lot of demand letters just being auto-generated essentially and sent out to companies.
Sure. We deal with those a lot. I mean, they come in and you do much the same investigation, right? You want to figure out what the consent records show, how did the campaign look, mm-hmm. Get that back to the plaintiff's attorney, let them know that there's really no there. So you behave in much the same way, but at least you can huddle up, get your communications protected by the attorney-client privilege, and just make sure that everybody's feeling confident about the way the business is moving and the campaigns are running.
Cool. Anything else that brands, obviously we have a bunch of information on YouTube. This is not, just be very, very clear, this is not the only TCPA issue is just people texting in and can't opt out. There are many, many different, facets of cases and different use cases and issues. So, this is not just the only thing you need to worry about. This is just one, specific thing and one use case that was kind of, I think, before they started filing these types of cases, this very narrow, subset of cases under the TCPA with text messaging as well. I think most people didn't even think this would be a thing, and I think people have now kind of got used to it, but there are also dozens of other things, which is why we always recommend here at Tatango, and we kind of have to state it just to make sure, is these videos, all the videos on our website, the videos with Innovista Law here, are to educate people to, kind of give them enough information that they can go to Innovista Law, they can go to their legal counsel and go, hey, we haven't really thought about this, or maybe we should discuss this. But it should never be you take this information from this video and then go implement it or execute on it or change something because of it. Always consent legal counsel, whether that's inside or outside your company. You did a very good disclaimer there, Derek.
I like to say it's cocktail talk without the cocktails.
Exactly. Now, speaking of resources and free resources, you guys have a bunch of resources on your website. What's your website?
It's tcpadefenseforce.com.
Okay, tcpadefenseforce.com. They have a great blog. So if you want to stay up to date on like every case that's happening, all the rulings, they're usually the first one that kind of posts about it. Then we'll do a video a week later, maybe. So you guys have been doing a really good job. And then is there anything else that brands need to be aware? It seems like in this case is just really, really check. Number one, make sure you're opting in people, which it looks like Kohl's was, and even the plaintiff claimed that she did opt in, which is good because that's a whole nother TCPA issue. Right. But this one, it looks like, just make sure that, your text message responses to help stop all these things. Number one, for stop and unsubscribe and quit and end, you're unsubscribing them. That's always a good thing to test because I have seen some cases where the software provider had a glitch in their system and it didn't unsubscribe them.
That's a different story.
That's extremely frustrating from a consumer perspective. So always test your SMS campaign. I think that's number one. Mm-hmm. Number two is make sure your, help is working and the stop is working and it responds back appropriately. Then also make sure that when you text in, whether it's just texting in randomly or whether it's texting in response to a mass message, text also random stuff to your help message and your stop message and see all of those responses and make sure that they have enough information in there, maybe even overkill, because you have 160 characters. Why not?
Right.
Put in enough info in there that somebody like your grandfather, like your father, maybe that doesn't text very much, or maybe doesn't even text at all, never sort of WhatsApp or Facebook, they don't use those things. Mm-hmm. And if they were presented with that message, would they look at it? I'm talking about the judge here. Would they look at it and go, yeah, that seems pretty reasonable. Like, I don't text, but I get what they're saying, and that seems reasonable. Mm-hmm. So I think let's call it the grandfather test, even though my grandfather texts all the time. So, well, that sounds good. I
don't know the last time my grandfather got his out of the glove box, but okay.
Yeah, I do have another grandparents. They're a little less texting focused, but right. I love them both. So, yeah. Okay, well, that's been another TCPA review. This one was from Giano. Again, Amy, essentially the plaintiff, a person suing Kohl's department stores for not even sending unsolicited text message right up front, but when she tried to opt out, she couldn't opt out, and then all those text messages obviously were unsolicited because she had asked to opt out.
Right.
Again, my name is Derek Johnson with Tatango.com, and I'm here with Joe Bowser from Innovista Law, home of the TCPA Defense Force. Check out their website. They have some great resources. So do we, and these videos as well. And stay up to date, and we're trying to do these videos as much as we can for the TCPA cases, so text message marketers can learn about them and then learn from them. So again, thanks, Joe, for joining us, and thanks, everyone, for joining us as well.
Thanks, everybody. Thanks, Derek.
Thanks, Joe.
Bye now.